This has been used by all governments, state and central governments, successive governments, to further their political aims. But the Congress government has been equally complicit in using the sedition law. Calling it a historic judgment, I don't know whether it is overstating a matter.
How do you feel about the order that the court has given yesterday?
The order that the court has given yesterday is an interim order. And I think the interim order was given because the government made a U-turn up to the 8th of May. They were strongly defending the sedition law. And suddenly they made a U-turn saying that we are going to review the law, and there is no need for the court to continue with the examination of the law. And that, in fact, caused the petitioners to ask for a stay on the law pending the review by the government of the sedition law. They said they would review the sedition law, and pending the review of the sedition law, since the Solicitor General had not given a timeline or a time period within which it would be reviewed.
Now, many asked why the court did not put a temporary blanket ban and say that, hey, no new cases should be filed at all till the case is being heard. Can you help our viewers understand why the court did not do so?
I am not, I don't know whether I am competent to answer that question, but at the same time, I would think that the court made a mature decision, because putting a blanket ban as a stay would have been actually interference with the executive. Whereas the government has said that we are going to review the situation, review the law, and that there is no need for the court to continue with the hearings, which could possibly be interpreted as an interference in the judicial process.
The center has suggested that Section 124A will be registered. If an officer not below the rank of an SP is satisfied with the claims being made and records his satisfaction in writing. Now, do you think that it is just another way of keeping the law intact and actually might be a dangerous precedent to leave it on the discretion of this one so-called SP that the center suggests should be appointed?
The question of having whether it's a superintendent police level or some other level doesn't really have any meaning in terms of our petition. It will only perpetuate the use of the sedition law. And even government itself has said that the sedition law is not in keeping with the mood of the mood of the people and the political atmosphere. And they brought out the issue of Hanuman Chalisa being chanted in front of Matoshri, and they're being charged with sedition. So it's clear that government itself is not happy with the sedition law. And they say they will review the sedition law, and government and parliament are fully competent to review the sedition law. It may take time, but they were not prepared to lay down a timeline or a period within which they would do the review.
Are the previous regimes not equally responsible for the mess that our democracy is in with the misuse of the sedition law? for not doing away with the law for so many decades in the first place?
Of course, precisely. All the governments since independence actually, and this has been used by all governments, state and central governments, successive governments, to further their political aims, rather than actually there being a threat to the state. Calling it a historic judgment, I don't know whether it is overstating a matter, because I think the word historic was used possibly by the Congress government. I'm not sure. But the Congress government has been equally complicit in using the sedition law. So the way that it would go forward is only that the government and the parliament could review the sedition law and in their wisdom repeal it or amend it or do whatever. And the judicial process should continue.
Thank you so much, sir. Thank you so much for speaking to the Quint. It was very insightful speaking to you.